Administrative law, a very interesting branch of public law. We'll try to explain administrative law with a very simple example. There was a beautiful park in the middle of the town. One watchman was appointed to take care of the park. Few benches were there inside the park and few kids used to play inside the park every day. After some days, a fruit vendor came outside the park and put a stall or put a small shop right in front of the park. Two more toy vendors came and they put their stalls near the fruit vendor. After some days, traffic in the area increased and lots of kids started paying visit to the park. So two watchmen were needed now and two watchmen were appointed. Suddenly, due to the increased traffic in the park area, traffic outside also increased and one extra policeman was appointed as a traffic police to take care of the traffic. After certain days, town committee decided to reduce the speed in the park area to reduce the number of accidents in the area. So speed limit was reduced in the park area. After some days, town committee decided that lots of people are visiting a park, so they put a ticket for park entry. So a different committee was made to take care of the park. See, there was one park, now there are like multiple watchmen are there, multiple policemen are there, multiple laws are there to take care of that park, and somehow work inside the park and work relating to park also increased. Same thing happened in the case of administrative law, and that's how administrative law came to our country, and it is still there because it is a need of time. Hey everyone, Dr. Vaishali here. Welcome to Law Simple, Pure and to the Core. Today's topic of discussion is administrative law. While writing your answer in the question paper, you are supposed to follow certain points. For example, what is administrative law? What is the history of administrative law in India? What is the need of administrative law? What are the various definitions of administrative law? Nature and scope of administrative law. Then benefits or advantages of administrative law, and then you are supposed to conclude your answer. Please try to go through all these points. Let us begin with what is administrative law. As I told you, in law, things speak for themselves. Administrative law means law relating to administration. Now, what is administration? Administration is a part of governmental function. Day-to-day regulating activities of certain departments is like taking care of the police department, taking care of the universities, providing sanitary facilities in a town, controlling pollution. This is nothing but administration, and everything relating to these functions is called administrative law. Next thing, what is the history of administrative law in India? As you all know, administrative law is not codified. There are case laws which are followed, and there are certain principles relating to administrative law which are followed in India. It is unwritten, it is uncodified, and it is a judgment law. In ancient India, administrative law was there. Like in Mughal period, Akbar's Navratna Darbar, it was nothing but administrative law. Kings used to keep their administrator. Shivaji's Ashtapradhan Mandal was nothing but administrative law, but it was not the same administrative law as we know it today. Then how did administrative law came to our country? Earlier in France, there was a thing called administrative law, and it was called as droit administrative. Droit means two and administrative means administration. Two types of administration. One for ordinary man and one for administrative authorities. In Britain, there was no administrative law. In India, after the independence, when functions of state increased, administrative law came to our country, and it is still there. What is the need of administrative law? Actually, growth of administrative law is associated with growth of society. when India got independence, India was a police state. In police state, function of a state is like that of police, maintain peace and order in society. So functions of state, they were limited. During the middle period of development, which was called as a laissez-faire era, during that era, unlimited contractual freedom was given to people or to industrialists, and no interference policy was taken by the state. Afterwards, in 19th century, when India became a developing country, which was no more underdeveloped country but became a developing country, functions of state increased by many fold. As you know, there are three departments or three organs of a state: legislature, executive and judiciary. Legislature performs lawmaking function, judiciary performs adjudicating function, and executive performs executing or law implementing function. Function of each and every organ of the government increased because of the welfare state. Because in welfare state, state goes beyond its police duties and performs something extra for its citizens. Examples: providing good schools, providing free education, providing pollution-free atmosphere, controlling traffic, regulating human conditions at work, and so on. So these functions increased, and that's why administrative law was recognized as a need of time. Example: as you all know, legislature performs legislative functions. Legislative function is nothing but lawmaking. But legislature cannot make law on each and everything which is needed. For example, in your city, traffic has increased and you need some extra traffic police, or you need some special traffic law. Legislature cannot sit in session and make a traffic law for your city, right? So that part of lawmaking is given to the authorities who work in the city office. So here legislature is delegating some of its powers to administrative authorities, and that's why that delegation is a need of time. Second thing, as we know, judiciary performs the adjudicating function, or hears the disputes and gives the decision. But judiciary cannot decide each and every petty matter because judicial burden is already more and more. So some part of that judicial function is given to administrative authorities, and they perform the function called administrative adjudication. Again, it is a need of time. It is convenience also, and hence in the new welfare state, that old concept of separation of powers is dissolved to some extent, and administrative law came as a need of time. So administrative law is nothing but a need of time. Various definitions of administrative law are provided by various jurists. According to Sir Ivor Jennings, administrative law is a law relating to administration. It determines the organization, powers and duties of administrative authorities. According to Wade, administrative law is the law relating to control of governmental power. According to K.C. Davis, administrative law is the law concerning the powers and procedures of administrative agencies, including especially the law governing judicial review of administrative action. According to Griffith and Street, the main object of administrative law is the operation and control of administrative authorities. So summarizing all these definitions, we can say that administrative law is about administration. It is about powers and functions of administrative authorities. It is about control on administrative authorities. It is about delegation of some functions to the administrative authorities, and ultimately the remedies which are available when administrative authorities cross their powers or try to go behind their power. So this is there in the administrative law. So at the end you can provide your own definition of administrative law, that it is everything about administration. Next point in our discussion is, what is the scope of administrative law? Always remember, when a question on scope of any subject is asked, you have to review the entire subject, right? So what is the scope of administrative law? It's about powers of administrative authorities. It's about functions of administrative authorities. It is about limits on the power of executive authorities. In case the power is misused, what are the remedies available? Then who will review the power, or who will review the decision of administrative authorities? Agencies like Lokpal and Lokyukta, which are appointed to keep some control on administrative authorities. So everything comes within the scope of administrative law. So all the topics which are there in your syllabus are nothing but scope of administrative law. So always understand that whenever question like scope, meaning and definition is asked, you have to review the entire subject. So you don't have to prepare anything separate for these type of questions. You can answer them logically. Next point of discussion is nature of administrative law. Concerning nature, administrative law is a part of public law, and in case of public law, second party to a dispute is always state, because it is a duty of a state to provide and to take care of administration, day-to-day administration, and hence like constitutional law matters and criminal law matters, in case of administrative law as well, the second party is always state. Next point is, what are the benefits or functions of administrative law? Concerning benefits, first benefit of administrative law is administrative authorities can take preventive measures. Usually what happens, if we want to put prevention on something like injunction, you have to go to a court of law and file a suit. But in case of administrative authorities, they can do it without filing a case, and they can take a suo motu action, and they can go and prevent some harmful shop or some harmful activity. So administrative authorities can take preventive action. Second thing, it is flexible. Usually what happens, in case of legislative law, you have to wait for the next session. But in case of administrative law, new law can be made. It can be tried for some time, and if it is not suitable, it can be changed. So that element of flexibility is there in case of administrative lawmaking. Next thing, as we all know, judicial formalities are extremely technical, but in case of administrative adjudication, they can avoid the technicalities and straightway give the judgment. And in this way, it is less technical, it is less formalistic, and that's why administrative law is or administrative functions are quick as compared to legislative functions or traditional judicial functions. So this is there in the nature and scope of administrative law, and then you have to conclude, you have to like summarize everything in the conclusion. So that's it about administrative nature and scope of administrative law. There are lots of other topics like delegated legislation, then administrative adjudication, judicial review of delegated legislation and administrative adjudication, rule of law, separation of powers, Lokpal and Lokyuktas, and then the writ remedies which are available in case of administrative misuse of power. So we will discuss all these topics one by one. So stay tuned till my next lecture. Please try to like and subscribe this YouTube channel. I'm running this channel exclusively for your benefit. So see you in the next lecture. Goodbye and good luck.